Lawyers have read it. What is a detail that your client failed to bring up to you that completely lost you the case? Story 1. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood. Same detectives on my case and this new theft. They fingerprint the guy, and the fingerprints match the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and my tie. I tell the district attorney. He says there's really no way to prove it. However, the tie he chose to wear was a one-of-kind street map of San Francisco, and I still had all the documentation to prove it. The district attorney's eyes widen, and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. Story 2. Little late to the party, but here goes, and obligatory, not my client. Company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company, friendly and outgoing. Though we had heard rumblings that the COO was rather hands-on with the work and with female employees. Apparently, there was a walk-away package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meetings didn't raise any flags. The COO emphatically denied having any contact with her outside of work. The lawyers asked the question a half-dozen different ways, and each time the COO denied any out-of-work contact. Later, we meet with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said, but I never had contact with her. It's not like I delivered the flowers myself. Guo got terminated for cause, so no walkaway package. At her request, the woman was given PTO until after the acquisition, then moved to another one of the companies under our umbrella. Story 3. Lawyer in the UK. I acted for a member of a famous pedophile hunting group. My client was charged with various offenses relating to his vigilantism, most seriously, causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in statute or at common law, contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish pedophiles properly, then it's left to men like my client to take the law into their own hands. A hoarse argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of child stupid graphy on it. He himself was a massive pedo. Edit, spelling edit 2, spelling again. Story 4. Minor traffic cases can be the worst for this, believe it or not. Because they are short and simple, and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in a 55. No big deal if she does a driving improvement course, the court will usually dismiss or reduce those, since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 asterisk up an unplowed snow lane asterisk, to get around all the others' cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she did, claimed she'd just forgotten to mention it. Now, maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consults, give my honest assessment if the case is even worth doing, and so by omitting that detail, she harmed herself for no reason. At least she took it well and didn't get defensive. Story 5. Friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asked the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they charging me with assault. I never touched her. I just threw an AC at her." This is nonsense. Judge rescinded plea deal because of defendant's attitude, lack of remorse, went to trial, and got a year in jail. Story 6. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. Story 7. I'm a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and Department of Children Court Services, we have a pre-trial to try and convince guardians. I meet with my client before the hearing to see if anything changed. Nope, all good. Let's get my kids. Great, that's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1. That no longer is working. 2. No longer in apartment. 3. Doesn't want to have a relationship with guardians despite her kids loving them. 4. Won't send her kids pictures of the toys they miss and can't have. 5. Plans on moving out of state. 6. Thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant. All in the matter of 15 seconds, I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since last July. Edit to clarify. Client was working really hard to get everything right, and legitimately had everything going for her prior to this hearing. I was not making false representations or trying to get a monster reinstated. This was a true bombshell, as I did my due diligence to make sure things were on the up and up and statutory requirements were met. Things fell apart very fast, apparently. This was a very atypical situation. Parents typically do a really good job working hard to meet their requirements. Story 8. I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long, drawn-out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple of days prior, the couple decided to get back together, and instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people, and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury, and the couple was adamant that they didn't think that them getting back together was a detail any of their attorneys needed to know. Edit. Yes, in some states there are jury trials for divorces. However, this particular case wasn't for the divorce, but for a cause of action stemming from the divorce, marital property. It was a jury trial. Story 9. I'm a public defender in an area with lots of meth use. Meth makes most people talk, a lot. So I can't tell you how many clients forget to mention that they got to the jail still high and called their mom/girlfriend/buddy on the recorded jail phone, and not only confessed to the crime, but also brainstormed whatever alibi or version of events I'm relying on to defend them. Edit. I'm seeing this question a lot, so I'll add some info here. This is not legal advice, just explaining things a bit more. Calls to a lawyer are privileged and generally go through dedicated lines that aren't recorded depending on the facility. Calls to family, friends, etc. through the normal phones are not privileged, are generally recorded, and can be used in court. There are usually printed signs near the phones and a recorded warning before each call that this is the case. Story 10. Credit card theft fraud case. When I was a young lawyer back in the late 80s, I was trying this guy on a CC case, and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how could she be so sure it was my client. She looked at my client who was wearing the most obnoxiously yellow shirt imaginable and said, "Because not only does he completely match the description I just gave you, but he's wearing the exact same shirt I sold him." The jury convicted him, and I learned that day to better prepare my clients for trial. Story 11. There's a rule you're supposed to follow when questioning trial witnesses, and that rule is to never ask a question you don't know the answer to. Despite this rule, lawyers often ask small, apparently inconsequential questions which are necessary to set the scene, but are so inconsequential or obvious that their answers are fairly presumed. This case was an exception to that general presumption. The defendant was arrested on a warrant and transported to jail. After booking him into jail, the officer returned to his vehicle and discovered a baggie of sweets sitting right in the middle of the back seat. The defendant was charged with possession. At trial, the officer explained that he routinely searches his vehicle before his shift starts and after any time he transports someone in the back seat. The defense attorney tried to poke holes in the story, but the officer's testimony was remarkably consistent. The officer was fastidious about checking his vehicle. The appearance of the sweets coincided with the defendant's presence in the vehicle. Then, as the defense attorney was running out of questions, he threw out the question: was there anyone else in the back seat of the vehicle? It was a Hail Mary. Even when there are multiple arrests, police tend not to transport more than one arrestee at a time if they can help it. There was no reason to believe anyone else could have feasibly been in the back seat with the defendant. Though it's no surprise to you, the defense attorney and prosecutor were stunned when the answer came back as yes. Turns out, the defendant was with his girlfriend when he was arrested, and the officer courteously agreed to drive her to her apartment before taking her boyfriend to jail. This fact was not included in the police report. The officer never told the prosecutor, and shockingly, the defendant never told his attorney. There was a palpable pause as this fact sunk in. Since there was another person in the back seat, there was more than enough reasonable doubt. Proofs were concluded, and the prosecutor threw out a half-hearted closing. The not guilty verdict was a given. Because of this case, I learned to never assume a fact no matter how obvious it may seem. Story 12. I am actually a lawyer, but I was only watching this trial, not participating. So the case was that Woman A had hit Woman B in the head with a heavy beer pint at a bar, and Woman B got pretty serious injuries. The defense claimed that Woman A had not hit anyone with the pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head. Thus, it was an accident, and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial. And the tape clearly showed in HD as A walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer, and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along, "Thrown, eh?" And the defense lawyer said that due to technical difficulties, he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty, so yeah, I was completely dumbfounded. Story 13. And it's not even my stories but my dad's. He was working as a fraud investigator for an insurance company. I have a few stories of his, but here's two of them. Guy was claiming theft of multiple items, but mainly a ring. Things weren't adding up, so my dad and the insurance company's lawyer decided to do a depot of him. Guy shows up and is doing the depot when my dad notices the guy is wearing the exact ring he's claiming was stolen. My dad slides a note to the lawyer telling him the guy's wearing the ring. Once the note got slid, the guy realized what happened and put his hands under the table and took the ring off. They asked him to stand up and lo and behold, the ring fell to the ground. Another one is a guy claiming a break-in and theft. Immediately things weren't adding up as the window was broken out instead of in. The guy submitted Polaroids of items he claimed were his, like TVs and such. Thing is, in the Polaroids, you could see the reflection of the store they were in on the glass. He also claimed numerous CDs records, but oddly enough, every single one started with an R, S, or a T. We're talking hundreds of CDs records. My dad was about to deny the claim in person, but noticed he had a gun on the table, so decided to do it over the phone. Ready for an escalation? Later, this same guy was arrested for beheading A and throwing her head in the river. Story 14. My father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids, and so on. In the middle of the trial, a pen rolled off the table and she is bending over trying to reach it from her chair. But Pen was too far away, so she stands up and bends over and picks it up and goes back to her seat as if nothing is out of the ordinary. My dad is just looking at her, and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay, and her response was that she was fine. Her attorney leaned over and said something to her, and she then loudly started complaining about her back and how much her back hurt, but no one believed her LOL. Story 15. This one ended my marriage. Well, it was the start of the end of marriage. My husband lost his job in the title mortgage business. Applied for unemployment, got denied. I decide to help him with his appeal hearing. I asked him multiple times before the hearing, "Is there anything you did that caused them fire you?" He says no, absolutely not. They fired him out of nowhere. Hearing day comes. He testifies under oath that he did nothing wrong, was a good employee, no issues. Upon cross-examination, the other attorney pulls out documents from one of his real estate closings, documents he forged and backdated. Had to admit he perjured himself. Needless to say, he didn't get unemployment and he didn't sleep at home that night. Story 16. Not my case, which is a gift from above, really. Civil trial before a jury for injuries and prop damage from a MVA, and punitive damages because defendant was intoxicated at the time of the accident. Let's call defendant DUI. Almost doesn't need to be said, but before DUI ever stepped foot in court, they would have been prepped repeatedly, first for the deposition and then for trial testimony, with the standard questions. Were there any prior incidents, arrests, convictions, anything that can be used to impeach any of DUI's testimony, yada yada, over hours? Denies everything and is as clean as a clean whistle. Thus, at trial, defense counsel, DC, puts DUI on the stand to give them an opportunity to tell the jury of their contrition for this one-time error in judgment, describe the difficult time DUI was going through at the time, and otherwise show themselves to the jury as an upstanding member of society in order to reduce punitive damages. It goes well. Then plaintiff's counsel, PA, gets to cross. I'm going to paraphrase what allegedly happened next, which is purely hearsay. PA. Earlier, you testified that this was a one-time mistake and you've learned your lesson. Is that correct? DUI. Yes. PA. Isn't it true that you've already been convicted of DUI in another state? Asterisk DUI sits silent as DC immediately objects, but it's properly overruled and DUI must answer. Since what happens next is impeachment, I'll skip the objections, but suffice to say they were being fired off as rapidly as a machine gun, and just as rapidly overruled. DUI. Yes. PA. And isn't it true that in your prior DUI a child passed away? Asterisk, you can imagine what's happening in the courtroom and most importantly amongst the jury, asterisk. And you think it's over. Stick a fork in DUI. It's done. But then Pennsylvania goes for the jugular. Do you remember the name of that little child that you terminated while you were driving while intoxicated? IMO, this question is one for the ages. More powerful than the old, when did you stop beating your wife? Because no matter how you answer, and that is why you never ever lie to your attorney. Story 17. I had a client who, despite being a large man, had been domestically abused by his much smaller wife throughout their marriage. After the divorce, she turned her anger on their son. He ran away one day to live with his dad, and we filed to restrict her parenting time and for a permanent modification. At the permanent hearing, she denied being abusive to the child or my client in front of the child, said she never threatened anyone ever, and that she never made disparaging remarks about my client in front of their son. What she didn't know, and therefore hadn't told her attorney, is that he had recorded multiple instances of her abuse. So I called my client back up for rebuttal and played an audio recording of her screaming at my client, threatening to break his face in and calling him a loser, all while the child could be heard in the background begging her to stop. I looked over at the other attorney, and she had her face in her hands. We won. Story 18. Not me, but my mentor. This is the reason you never ask questions that you don't already know the answer to in court. During the trial with the judge on a divorce matter, the wife brought up that he had abused her during the course of their marriage. Client whispers to my mentor that that is absolutely not true. On the stand, during his portion of testimony, my mentor asks, "At any point in the marriage, did you lay your hands on your wife?" One time we were having an argument and I held her down on the couch until she stopped arguing with me. What? My mentor said it was like she could see it happening in slow motion and all the alarm bells were going off in her head because he had never mentioned this, and apparently to him this was not abuse. The judge gave wife a lot more money as a result and husband was baffled. My mentor was fuming. Ite. Husband admitted this was the only time he had laid hands on wife. My mentor was more peeved because she had thought the case was in the bag, since wife had abandoned the kids with husband to run off with her lover down in Florida, and literally only came back to the state to get the divorce done. Husband had been noted as being a great dad to the kids and a good figure in the community. Hence why she was so no shocked at his answer. Story 19. I was approached by this attorney to work for him for free to go after smugglers. This guy had been arrested for dumping goods onto American markets that violated trade agreements. In his arrest, a bunch of goods were left in warehouses to rot, and their owners, his clients, were never paid. This attorney showed me that this smuggler had assets, and that he had gone to the criminal trial and gotten the judge to set aside $2 million of the criminal penalties to settle his client's debts. He had receipts, invoices, all of the paperwork. He just needed associates to help him take the case to trial. He wanted me to work for free, but he would pay me on contingency once he obtained the verdict. He had 2 other attorneys working for him with the same deal. I worked on the case for a short while, but luckily moved on to other things. The other 2 attorneys worked on that case for over 2 years. At one point, they negotiated a $1.5 million settlement of all claims. The attorney in charge rejected the offer because he was convinced he could get twice as much at trial. In the end, the case settled for $200K because none of the clients would enter the United States to testify, for fear of being arrested. The 2 associates got $8K apiece for 2 years of work. Story 20. Years ago, I had a client charged with drunk in public. It's a minor infraction, but he was on probation, so he needed to fight it. He told me he was very drunk that night, but had made it to the lobby of his brother's apartment and was waiting for him to come down to get him upstairs. I take this information and run with it, bringing photos of the apartment complex and the bylaws to court. My goal was to prove that the lobby of the apartment was secured to guests and residents only, which would arguably take the drunkenness out of being in public. There is no formal discovery for minor infractions in my state. Since there isn't a real option for a plea deal on the minor charge and wanting to ambush the officer with my argument, I do not discuss the case with him, and we go to trial. The wheels came off the wagon when the officer testified that he encountered my client at an apartment building on the other side of the city. He was outside at the call box, not even in the lobby of this different building, rambling AMD, barely able to stand. I'm whispering to my client about this reversal, and he slumps over and says something to the effect of, "Sorry, I meant to go to my brother's apartment. Maybe that's why he couldn't find me." And he sounded angry on that phone? Cross-examination was not fruitful. It was basically, "Officer, are you really sure it happened where you said it did and not at this other apartment building miles away?" Closing argument that he wasn't that drunk also didn't get us anywhere. In the end, there was a fast guilty finding, a minor fine, wasted ink and paper from printing useless exhibits, and light sanctions later on the probation violation. Story 21. I was actually on a jury. Guy was suing a business, said he got injured, couldn't work for 3 years. Defense counsel asterisk, "Sir, isn't it true that you spent 18 of those months in prison for armed robbery?" Edit for more info. Guy was saying he was shopping at a major grocery store chain and slipped in some water on the ground in front of a freezer. Guy has cell phone video his wife made of him in the water, and we could hear her saying that the water wasn't showing up on video and to splash it with his hand so it would look better in the video. It also came out that he'd had 3 prior convictions for crimes of dishonesty. That may not be the exact term, but something similar, for things like shoplifting and other petty crimes. Second edit for more info while I'm on my lunch break. Guy was representing himself asterisk pro se asterisk. Defense counsel asked him if his inability to work could be from the 2 previous knee injuries he'd had. When asked how they knew about those injuries, he was told his previous lawyer had given the defense his medical records upon request. Guy wanted to enter his MRIs as evidence, but had no one there as an expert witness to explain to the jury what they showed. He wanted to show us what the results were. Story 22. Not a lawyer, but going to law school. I worked for a defense attorney who did a lot of federal work. One of our cases was with this guy charged with close relationship trafficking of minors. We met him at the prison to interview him, and he swore up and down he had nothing to do with this, and that he didn't even know the girls. A month or so later, heaps of evidence from the U.S. Attorney's Office comes in, and it's pages of Snapchat messages and texts between him and these girls, video confessions from every co-defendant and victim saying our guy was the ringleader, proof of him checking in, out of different motel rooms, etc. We showed him the evidence, and he claimed his co-defendants were conspiring against him. He continued to deny everything and wanted to go to trial, but we repeatedly told him that would not be wise because of all the evidence against him. He ended up requesting a new attorney to be appointed, claiming that we were ineffective. To this day, my old boss and I reminisce about how difficult this client was when we catch up on the phone. Story 23. Not a lawyer, but a woman I know received several hefty speeding fines. In my country, you can go see a magistrate to have the fines reduced if you plead poverty. She heard about this and decided to give it a shot, so she went to court and told the magistrate a sob story about not having enough money. The magistrate heard her out. Then he asked her, "Madam, what type of car do you drive?" She replied in a tiny voice, "A Porsche." Edit. Many have raised the fair point that a Porsche doesn't necessarily cost that much and isn't indicative of her financial status. So I'll add that it was not a beat-up or old model at the time. She could have paid the fines without breaking the bank. She was just pushing her luck. She's a wealthy woman who just didn't want to pay her fines, and the magistrate wasn't having any of it. Story 24. Not me, but my dad represented a guy in a civil case. He doesn't normally do criminal law, but in this instance, the question of a forged signature came up, and his client lied, saying he didn't forge it. My dad was very clear in explaining that admitting to him wouldn't land him in jail. It would just allow him to build a better defense, but he still denied forgery, and so my dad rolled with it. He said his case was completely cut up once it came out that yes, in fact, his client did forge the signature. Guys and gals, your lawyers aren't a snitch. They're trying to get you the best possible result. Asterisk, always asterisk, be honest to your lawyer. Story 25. I'm late to this, but I'll share mine anyway. TL doctor, client forged the bank statements that her entire wrongful foreclosure case was based on. We had clients who said the bank wrongly foreclosed on their house. The wife provided bank statements. Their checking account was in a different bank than their mortgage, showing that they had made their payments every single month for the past several years. I checked through each one to make sure they all showed payments and looked good. There was also proof that the notice of foreclosure was never actually delivered to them. The bank was baffled. Expert witnesses we talked with confirmed that during the recession, a lot of banks' record-keeping had gone to cow, and a wrongful foreclosure could definitely result from that. We got to mediation, and the first thing the bank comes back with was that upon close examination, they had noticed one tiny error on the bank statements, so they were calling off mediation and subpoenaing statements from the bank itself to check against our clients' statements. Our clients were pissed, and so were we. So what if the bank had made a tiny error? The opposing side got the subpoenaed statements a couple weeks later and sent them to us, and I had the joy of comparing them. I quickly noticed that there were differences between the ones from our clients and the subpoenaed ones in the electronic withdrawals section. Our client had used a PDF editor to delete an entry in that section on every statement, add the mortgage payment, and then adjust the totals, carrying them over each month. We approached our clients about it, and we said, "These look forged. We can drop the case, or you can explain what the issue is." The wife said, "We should probably drop the case." She never confessed to us about forging them, but without a doubt, she had forged them. Her husband had no idea. He actually wasn't on the call where we accused her of the forgery, and he called a few weeks later asking for a case update. That was not fun, telling him his wife had lied to him for the last year and a half. The opposing side said they'd be okay with us dropping the case as long as our clients paid their attorney fees. Our clients were happy to do that. It's actually very lucky the defendant bank didn't try to get them charged criminally. Story 26. Not a lawyer, but a manager in an unfair dismissal case. One of the shift supervisors caught a call center worker making private phone calls during his shift. All employees sign an agreement that they are not to use office phones for personal calls. She told me what she had heard, and we checked the phone records and found he had made over a dozen calls to the same number in the previous week. It was very clear that they were private calls because they were calls to a boy-close relationship line. Now, the specific number he was calling was totally irrelevant as far as I was concerned, but given the potentially sensitive nature of the calls, I decided that it would be best to call him into the office, with witnesses, discuss what we had found, and issue him with an official warning. I typed up the warning and had it printed out and ready to go. When he came into the office with his chosen witness, I asked him if he was aware of the company's policy on private calls, and he said yes. I showed him the phone number he'd been caught dialing and asked him if he recognized it and if he had called it from the office phones. He immediately lost his cow, started yelling, and kicked his chair against the wall before shouting at everyone that he quit and storming out through the call center, hurling profanities left and right at the top of his lungs. I let my manager and the HR department know what had happened and got statements from everyone involved, including his witness. 2 days later, he turns up at the office with his solicitor, demanding an immediate meeting with the general manager. His solicitor wanted a big compensation payout, demanded that I be immediately fired, and suggested that he was going to pursue criminal charges against me personally for hate crimes because his client said that I had fired him for being boy. The general manager called me into the meeting and asked me to give my side of the story. I showed the solicitor the signed agreement regarding the private calls policy, the call records which showed all of the calls he had made during his shifts, and the warning I had typed and printed for making personal calls. I pointed out that at no point had the fact that the calls had been to a close relationship line been the issue, and that his attractiveness had nothing at all to do with what had happened. I then pointed out that I had signed statements from 3 witnesses that his client had quit and not actually been fired, and reminded him again that the company was only going to give him a warning in the first place, and had no intention of firing him at all. The solicitor took 2 or 3 deep breaths, apologized to the GM and myself for wasting our time, and specifically to me for the threats of legal action, which were not justified in light of the actual evidence, and walked out, literally pulling the client behind him. The cherry on top? 2 weeks later, I got a call from another call center I'd worked at previously, looking for a reference for him. Story 27. It was a simple bond hearing on a bad check case, $5K. So a felony. The biggest issue with these is that the judge just wants to be sure my client will come back for the new court date. I had just been hired the evening before by the client's crying and panicked wife, so I didn't get a chance to talk with him until right before the hearing. That morning I asked if he had ever been in trouble before. He had some minor charges in the past, but those had been resolved. He was now in his 40s and said he had been clean. So far we're golden. Me. Have you ever failed to appear in court before? Client, after some thought. Way back in college, I missed one court date because I was stupid. But that was it. Me, concerned about his pause. Are you sure? Client. Yes. We're good. Economic crime, established in the community, has been out of trouble for years, only missed one court date. This should work. We get before the judge and I present my case for bond. I go through my notes, present my argument, and the judge is patiently listening to my presentation. When I'm done, Judge. So this failure to appear was just because he was an irresponsible college student? Me. Yes, Your Honor. He now understands the importance of meeting his obligations with the court, including appearing when required. That was just a youthful mistake. Judge. Very well. I understand. Can you explain the other 9 failures to appear that also show up on his record? I went from calm confidence to embarrassment to barely controlled anger to what I hoped was a neutral expression. I looked at the client, and clearly the now 10 failures to appear were not as surprising to him as they were to me. Since he was pulling off the calm, confident look much better than I was, I turned back to the judge and said, I think he's in a better position to explain those right now. We got through the hearing. The judge was pissed, I was pissed, and he was just as calm. Although he was finally able to get bond, he had to borrow money from his family since he had to put down a whole lot more money than he expected. Don't lie to your attorney. Story 28. When I was a law student, I interned for a judge. One of the cases we were observing was an illegal lockout case, where this owner of a franchise location for an international cafe company claimed the landlord owner of the right to issue franchises in the U.S., happened to be same guy, just one day locked him, franchise owner, out. Landlord had claimed the franchise owner was selling unapproved merchandise with the company's logo on it. For 2 days, all we're hearing is about these cups the plaintiff allegedly made. Argument was that counterfeit merch violated terms of franchise and lease, which meant terminating both. Finally, the landlord is on the stand. The defense addy pulls out a shopping bag as he's about to introduce evidence. Me and the other interns are so excited. For 2 days, we've been hearing about these flipping cups, and, the landlord suddenly can't remember where he got the cups from. In response to one question, he says he got them at the cafe. In another, he says the corporate office gave it to him. Since he raised doubt about the source of the cups, the judge wouldn't let them in, and we never got to see them. The defense addy had to sadly put the bag away back into his briefcase. So yeah, lesson learned. Prepare your flipping witnesses, especially when you're trying to introduce critical evidence. Story 29. A postcard. While I was in law school, I worked in a state AG office, Administrative Appeals Division. Guy was appealing a huge tax bill for unpaid tax on his dairy farm's milk production. His entire defense and claimed basis for appeal was that he had zero notice of the requirements to report production, sale, and proceeds. In initial disclosures, pile of discovery, was a postcard from the state tax office from when he initially registered to obtain a state tax number. Very smart AAG laid low, sprung it on the guy after he has cemented his position 50 ways to Sunday. Exploded his whole theory, resulting in big judgment. Morale. Read your own discovery responses and document production before building your entire theory of the case. One piece of paper can terminate your client's position. This lesson has saved my bacon in 27 years of practice for sure. Story 30. Not a lawyer. My parents had a long, messy divorce that took 2.5 years in court. My dad claimed that my mother was trying to take 100% of everything based on a settlement offer she sent him. He failed to mention to his lawyers that her initial offer, also sent to his previous lawyers, was a 60-40th split, and she only sent that 100% one in response to an equally unreasonable offer from him. As soon as she could prove the initial offer was reasonable, the judge just basically ruled on everything according to that first offer. His lawyers were so angry because they built their entire case around the idea that she was the unreasonable one. I think it was something to do with arguing that she was not sending genuine settlement offers. I'm not sure why. His goal wasn't to win, it was to prolong the battle. But the original offer exposed him in the lie in front of the judge, which made the rest of the process go very quickly. Story 31. Had a work comp case where a client claimed he fell off the side of his truck while putting a tarp over the load and hurt his back. It seemed legit as he was taken to a hospital and they had given him meds. As we were pursuing the case, it turns out the company had a surveillance camera. The injury seemed fishy to the employer, so they looked at the recording. It turns out the idiot had climbed off the side of the truck, then laid down on the ground and started yelling for help. He had made the whole thing up. No wonder employers question work comp injuries. This guy ruined it for the legitimate claims. Story 32. My parents spent most of my childhood and were still arguing it years after I'd left home TBH, embroiled in a messy divorce. One of their biggest arguments was about my parentage. My mom claimed that my dad claimed that I wasn't his child and refused to engage with him until he admitted he was wrong. My dad refused to admit he was wrong and refused to engage with my mom until she apologized. Much later, I found out that those years spent arguing were all down to a typo on a court document which had my date of birth wrong by 10 years, thus having me being born after my dad had a vasectomy. Neither had mentioned the obvious typo to their legal representation, as I guess they thought fighting pointless battles in court for 5+ years was preferable to simply amending one number on a paper document. As an aside, one parent in particular went through multiple solicitors, barristers, insistent that each one had mismanaged the case, and to this day is still convinced that they were a model client who just had bad luck choosing representation. Story 33. Our client was involved in a lawsuit, and we managed to get the opposing party to come to the negotiating table to work out a $20 million settlement. This was great news because they were suing our client for $50 million. We spent months negotiating the details and drafting the settlement agreement. Finally, everything was ready. The parties were set to fly to our offices on Wednesday to sign the documents. They had to be signed in person and during a particular part of the day so that funds could be wired while the banks in two widely separated time zones were both open. On Tuesday, our client called us and told us the deal was off. Why? Because the loan they were using to pay the settlement hadn't come through. Asterisk loan, asterisk, that would have been nice to know. Asterisk. They had deliberately hidden the existence of the loan, even from their own lawyers. Story 34. Not a lawyer yet, but I clerked for a DA's office throughout law school. Obviously, we don't have clients, but I'll never forget this kidnapping case I worked on. It involved two Asian male defendants who were both the same age and looked relatively similar. Witness is on the stand and is asked to identify where the defendant who pushed an Uzi into his face is seated. It's clear the witnesses is having trouble differentiating the defendants. In a true moment of brilliance, one defendant raises his flipping hand and basically points to himself like, "Right here, bud." Hands down the dumbest cow I'd ever seen. I thought his defense attorney was going to have a brain aneurysm. Story 35. Ha! I have a story for this. I was in trial for domestic violence charges from my wife, now ex, where she claimed I had thrown white paint on my own car and proceeded to beat her up. What really happened was that we were arguing. She was destroying my things and throwing them out the window. I told her I was done, and so she decided to throw rocks at my car, tried to pick up a rock the size of my head to smash through the windshield. And when that proved too heavy, she grabbed a 1-gallon paint can to throw at my car. As she tried to throw the paint can at my car, I stopped her and tossed the can aside, at which point she tried to attack me with an ice scraper. At this point, I restrained her and sat on top of her until she calmed down. She did. I let her go. She ran to the busted-open paint can, scooped up paint with her hands, and threw it at my car. She then went back in the house. I went to the front door to ask for my things so I can get the hell out of there. She tried to kick me in the balls, but I caught her foot and held it, telling her to flipping chill. She tugged to get her foot back and ended up hitting her foot on the door frame, which caused a slight cut and bruise. Well, I left, and she called the cops saying I was beating her up and such. We go to trial, I defend myself, and she tells her story of the battered wife, that I was beating her up, threw paint at my own car, and that I slammed her foot in the door frame. At the trial, my lawyer pulls out the pictures of my black car covered in white paint and asks if I really threw paint at my own car. She, of course, says yes, but then my lawyer pulled out pictures the police station took of her to document her injuries. They were front and side views of her, but you can tell her hands were covered in white paint, like gloves. Plus, it came out that she was cheating, which was the original reason we were arguing in the first place. The jury acquitted me, and it was funny that I met the jury foreperson in the elevator as I was leaving the courthouse. She told me, "We decided to let you go because you need a divorce."